Sossin. And Justice Sossin really needs no introduction, so suffice it to say just a few things that he has served on the Court of Appeal for Ontario as of November 2020, on the Ontario Superior Court from 2018 to 2020, and as Dean of Osgoode Hall Law School from 2010 to 2018. So I hope everyone will join me in welcoming to the stage the Right Honourable Justice Lorne Sossin.
Thanks for the kind introduction. Thanks to the Centre, and thanks for adding the right to the Honourable, which whether earned or not, I'm keeping. I'm changing my cards. Thanks also to, of course, Gerard, more on that in a moment, to Justice Jamal for making time for this event, and again, he's had already a very warm visit at the University Faculty of Law. And I want to again thank all of you for taking time out. It's not an easy sell. Justiciability turns out to be way more fun than anyone realizes, but at first glance it doesn't have quite the compelling draw of some other areas, which turned out to be the reason that I first got a tenure stream job. So justiciability for me has been a wellspring that I've come back to on many occasions. The first edition of this book, a much thinner edition, was published exactly 25 years ago in the fall of 1999, and I'll tell you in a moment what led to it. But the job part was taking the advice of some people I knew at Osgoode Hall Law School, where I was applying to be tenure stream assistant professor, and I had been a student, so I knew some people. I said, "What's your best advice getting ready for a job talk and all the nerves?" And I'd worked on a few different things, but had that crisis of confidence. What can I really come in and pretend to be an expert on? And they said, from a number of different people, so I took this to be a kind of consensus view, pick something that everyone is a little invested in, and no one is invested in too much. So don't come in and talk about the rule of law. A lot of people care deeply about the rule of law, and stay away from Section 1 of the Charter. Lots of deep passion about that, and really stay away from the Charter entirely. And so I've been working on this, it's not an article, it's more of a book project on justiciability, and I have no idea what you'd have to say about that. I think it's perfect. It turns out to be a little bit about so many different areas of law, in particular the two areas that I was given to teach when I started, which was the wonderful course of civil procedure and the wonderful course of administrative law. And again, there is a tradition in the US and some other places of people doing those kind of public law and procedural justice courses together, but it wasn't really that common in Canada, and it led to this really interesting cross-fertilization of the puzzle that led me to sit down and write this book. It was a puzzle that started when I was in practice at the firm that's now Borden Ladner Gervais, and then was Borden and Elliott, and was really just one of those things you put in the file of an interesting problem you spent a day or two on writing a memo, and thought to yourself, if ever I had like the time, I would really love to dig deep in this. But I've now got 4 other memos on 4 other topics, and there it sat till I got a first contract position, bless you, that allowed me to finally sit down and come back to this puzzle. And I found what was compelling about it is it's one of those few areas of almost unrestricted judicial discretion, this gatekeeping of what the subject matter limits would be on what was subject to adjudication in the courts and what lay outside. And of course, for many litigants, when you're told it doesn't fall within the purview and it lay outside, that's in effect saying there is no way to get any kind of vindication of what you believe your rights to be, no resolution that again many people's lives will be affected by. So it mattered, these cases, as I was exploring them. And of course the accountability. For example, the giving of honors turns out to be one of these areas hotly contested in the justiciability field. If someone gets or doesn't get an Order of Canada. Should that be justiciable? And one can think of a whole bunch of reasons why it probably wouldn't be, not having a easy set of criteria. But to say to someone that that discretion could be abused, that it could be undertaken in bad faith, and there's nothing a court can do about it, is a very stark and, for many people, unsettling perspective. So justiciability matters in that sense too, around accountability. So anyway, where I landed with, as I began exploring it, what I realized more and more, this open-ended discretion needed some principles to coherently structure it. There needed to be some greater predictability, some form to this discretion, and that became the central argument, if you will, of the book. And again, organized around the idea that there's lots of good reasons why we don't want courts adjudicating certain kinds of disputes. And it turned out the good reasons all revolved either around legitimacy. Some disputes have been given to another body to resolve. Unruly MPPs are subject to the Speaker's adjudication, not a court's adjudication, and subject to some exceptions. And where the capacity simply isn't there. The arguments in the Wall case, the Highwood Congregation case, which will be known to many in the room from the Supreme Court's decision in 2018, concerned whether an individual did or did not follow the steps set out in Matthew chapter 18, verses 15 and 16 sufficiently. You could make legal arguments in a court of law about that, and both levels of Alberta court until the Supreme Court of Canada viewed that on the merits as being justiciable. But again, I think Justice Rowe, although he deals with that aspect in Obiter, provided some compelling reasons why a court may not be the best place to litigate religious dogma. So that became, again, the organizing principle: how to structure the discretion, how to find principles that were coherent in, again, cases that mattered to people, and how to also not avoid or elide the bigger questions. What should the judicial role be? And of course, that was a role that many people saw expanding in the charter era in particular, and in the culture of justification. There's a whole range of decisions that many people would love to see courts engage in that are frankly not historically where courts have been. So the pressure to take on more is always going to be there, and that's one reason why the book has continued to get larger. So let me finish with this. In 2012, so about 12 years after the first edition, I felt the itch in the file was getting sufficiently large to sit down and do a second edition. And sure enough, about 12 years after that, there was the itch again, but with a judicial day job, I didn't think I could satisfy that itch. I was going to say scratch it well enough, but that's probably mixing the metaphors too much. But I felt pulled in again. There's the Wall case, a number of others were such compelling interventions in this ongoing journey and discussion. I felt like, Al Pacino in Godfather 3, I'm trying to get out, he keeps pulling me back in. But unlike Godfather 3, which on almost any measure was not quite as good as Godfather 1 and 2, the third edition, I can guarantee you, of this book is just leagues better than the first two. And the reason for that is Gerard Kennedy. And sitting down with Gerard, who was a star graduate student at Osgoode during my last years as dean, and we had the chance to collaborate on an article and a book chapter. Seeing his energy and reach and just the kinetic set of ideas that he was grappling with was inspiration to invite him to join me in the third edition, and I hope more to come. And that led again to really tackling topics that should have been part of the first two and weren't, including a range of procedural justice issues, the law of standing, which had been, when I started this journey, a book recently published by Tom Cromwell, Locus Standi in the 90s, was still out there, so I didn't want to trench on his turf. But of course, if you're looking at the subject matter of what can be judicially reviewed, it's important to also look at who can bring forth those claims. And then the last thing I'll say, because Gerard's going to talk a bit more about some of the expanded aspects that he's contributed to, is for the first time there's a final chapter called Looking Forward, as we're anticipating more justiciability disputes to come, and it was a chance to explore the role of AI and its checkered possibilities for legal personhood and what it means to have an algorithm be able to either pursue or defend rights. And we also looked at, again, a case close to home, the Reese case on the legal standing of Lucy, the elephant at the Edmonton Zoo, and a divided court of appeal on that question and the implications for when non-human animals may be granted that ability to bring claims and what that would look like, who would stand in to pursue them. And finally, looking at a similar issue with respect to rivers and natural features that take on, again, personhood and community significance in Indigenous context, being given standing and justiciable rights to pursue in the Wahanganui context in New Zealand and in the Magpie River context in Quebec. So these are some of the justiciability debates to come. They're fascinating, they're compelling, but it's the very same puzzle I started off with 25 years ago, is how to structure the discretion in a principled, coherent way and take seriously why courts need to be the last resort for resolving important disputes, even difficult disputes, and the judicial process can't be a static one. It can't be that it's not dynamic and adapting and evolving, but it's never not going to have limits. And there's good reasons why we want or need some disputes to not be resolved in courts, and litigation isn't always the panacea or the answer. So let me leave it there with some further reflections on the book and the topic to come. And again, thank you for being a part of this and the generous welcome I've received at the university and from the center and Runnymede and the whole group tonight. Thanks.
Thanks very much, Justice Sossin. So we're going to hear now from your esteemed co-author, Professor Gerard Kennedy. So for anyone who doesn't know Gerard, he joined the U of A as an assistant prof in July 2023, having previously been a faculty member at the University of Manitoba. And aside from authoring more than 30 journal articles, Gerard is also the author of 5 books, which is pretty staggering. And that includes the Charter of Rights and Litigation, and of course the book that we're celebrating tonight, and I'm going to wave it again, because any opportunity I have, I'll wave it, Boundaries of Judicial Review. So please join me again in giving a very warm welcome to Professor Gerard Kennedy.
Well, thank you very much, Richard, for that kind introduction, and thank you all for being here on what might be one of the last nights Edmonton evenings of the fall. I know there are many other things you could have been doing with your time, so I'm particularly grateful that we're out here to celebrate. I have so many colleagues here. I can't thank you all individually. I'd really like to thank Chief Justice Couillard, President Flanagan, Dean Kelly, all for being here. It's very noted and appreciated. As Richard noted, I began this journey at the University of Manitoba, and I'd like to thank my dean there, Richard Jockelson, and Dean Kelly's predecessor, Dean Billingsley, for their contributions to my career, and indeed their support for this book. And Richard, thank you for bringing everything together tonight. The Center for Constitutional Studies, I'm honored to serve on the advisory board of it. It has a mandate to give, to be an outreach between the profession and the academy, and I think tonight is hopefully a good example of that, but then again, I'm not an objective observer. And I'd like to thank Tim and the Runnymede Society for co-sponsoring this evening and sponsoring a sub-project in Chapter 8 that I will return to. There are a few research assistants, Zainab Fada at the University of Manitoba, Carlene Petitum and Talia Wilson at the University of Alberta, who also did invaluable work for which I am very grateful. Lastly, most importantly, my spouse Jane is here. A bunch of time that should have been dedicating to moving from Manitoba to Alberta ended up being used for this project, and so thank you very much for that. So now with those, I guess, thank yous, and sort of very sincere out of the way, I perhaps want to go to the last two thank yous as well as some thoughts about this project as a whole. So about 9 years ago, I was sitting in my office on the 64th floor of First Canadian Place in Toronto, a few doors down from the gentleman here on my far left, now Justice Jamal. And I'd learned a lot in private practice. I'd always had an academic itch that I had sought to scratch, but at the end of my LLM, wasn't sure what I wanted to do a whole doctorate on. And with several years in practice, I felt I really had an interest in procedural law. And that led me to Osgood and Janet Walker and the man here, now Justice, and then Dean Lorne Sossin. And throughout my 4 years at Osgood, I really worked at the realm of procedural law and the intersection of public law. In the US, as you've heard, this is not at all an uncommon combination to study together. And yet in Canada, there were very few of us who were actually looking at this intersection. So when Dean Sossin asked me to work on an article with him for the Australian Federal Law Review, I felt extremely honored and jumped at the opportunity. And clearly something must have gone right, because a few years ago he asked me to work on the third edition of this book, for which I was completely floored and completely honored. And now we failed as a book launch. We didn't actually have books that you could buy tonight. But anyone who wants to buy it, believe you me, I'll let you know. And here we are 2 years later with the final project. So I'd like to just give maybe a few reflections on the process of writing the third edition, perhaps what has changed, and some interesting maturation of the law of justiciability in Canada. First, we now have a chapter on the procedural junctures at which matters of justiciability are raised, such as motions to strike, summary judgment motions. What's the intersection of discovery with all of this? Usually justiciability issues are brought at the outset, and there's very good reason for that. If a court has been asked to opine upon a matter that it has no business opining on, that should be resolved early and prevent all the problems. But that's not always the case, and now we're looking at how that's the case in terms of when might discovery be essential? What do you do when justiciable and non-justiciable issues are clearly intertwined? And what do you do when an issue becomes moot, which usually does not happen at the outset of the litigation, but happens later on? So hopefully we now have a comprehensive place to look at when you determine issues of justiciability procedurally. Second, we now have a chapter on standing. Now, there were previous chapters on mootness and rightness, and for anyone who's had the misfortune of studying law in the United States, which I know the three of us have, you know, standing, mootness, and rightness are usually considered three aspects that always need to be satisfied before a court can adjudicate a matter pursuant to Article 3. Canada has never had such cut and dry rules in that regard, but the underlying rationales for all three doctrines are still nonetheless present. And given that Professor Cromwell got another job and began writing about standing from a different capacity, we were able to analyze how the law of standing fits in as another boundary of judicial review, how public interest standing in particular incorporates a discussion of substantive justiciability right in it, and how a matter that's obviously substantively non-justiciable won't lead to a grant of standing, but a matter that is uncertain could still lead to a grant of standing. And we look at some recent case law in this regard, including Council of Canadians with Disabilities from the Supreme Court. We also noted, and I think this goes back to Justice Sossin's point regarding the what parties don't like being told their matter is not justiciable, there's remarkably little case law on private interest standing, or standing as of right. We would think that the reason for that might be Professor Scott's proof, parties tend not to litigate for a lark, They either have a real interest or just they acknowledge they're litigating for some ulterior purpose, potentially legitimate one, and then you analyze public interest standing. But I found that to be particularly interesting. So standing, ripeness, and mootness are all issues of procedure in many ways. One deals with the appropriateness of the plaintiff, the other two deal with issues of timing. But there's still another dimension of justiciability, which is, as been alluded to already, that of substance. There are areas where even if brought in a procedurally perfect manner, the court cannot or will not tread. Previously, this was dealt with in Justice Sossin's last edition of the book as one large chapter on political questions. The law has expanded in such a way that we divided that into 3 chapters, one of which roughly is analogous to what you would call, certainly in the States, political questions, an area of law that hasn't been adopted in Canada, but where the underlying rationales often show up in similar ways, though usually not with as cut and dry rules as you see in the United States, where there's a lot more discretion going on. We contrasted that to what was discussed in Chapter 7, which is issues of parliamentary process and procedure, which is now a standalone chapter and truly is an issue of curial jurisdiction, where insofar as it applies, parliamentary privilege prohibits courts from treading. And we've noticed that this has already been cited by the Supreme Court, unfortunately in 2 dissenting opinions. Justice Jamal may have something to say about that later on, but thank you, and thank you, Justice Rowe. I only regret you couldn't persuade your colleagues. And so if that was, I guess, the 2 paths of politics, one of which leads to discretionary issues of non-justiciability, the other is a more cut and dry issues of non-justiciability, the new Chapter 8 deals with an assortment of topics that don't raise those kinds of separation of powers concerns, but nonetheless courts are reluctant, and often very understandably, to tread. And so we discussed issues concerning social and economic rights, climate change litigation, honors, issues dealing with foreign relations, religious disputes, indigenous law, and we seek to explore when courts will or will not adjudicate in this area. Though this is an area, like the issues in Chapter 6, where we see principles, but not necessarily cut and dry rules. And we also seek to distinguish between a matter being declared substantively non-justiciable, which prevents the courts from being able to review at all, as opposed to yielding as a matter of prudence and deference to Parliament or the executive's view on what the law substantively should be. This distinction between non-justiciability and deference builds on some previous work I've done with Mary Angela Rowe, my former colleague at Osler, and I give her thanks in absentia. And then finally, we look to the future of justiciability. It is, to some extent, a fool's errand to imagine what the emerging issues in any area of law will actually be. So we kept that chapter short. Hopefully we don't end up being embarrassed, but I am very grateful for you all being here. We view this fundamentally as a treatise. It's a textbook, to be sure, to help the profession, but we nonetheless hopefully put a bit of our normative bent on it, even when there was constructive tension. And I hope that you, as members of law students, members of the judiciary and the profession, find it useful. Thank you all very much.
Thank you, Gerard. Okay, well, now we're going to hear from our final speaker of the night, Justice Mahmud Jamal. So just a brief bio. Justice Jamal was appointed to the Supreme Court of Canada, actually on Canada Day, is that right? In 2021, having previously served on the Ontario Court of Appeal for several years, and previously as director of the CCLA. So Justice Jamal, it's an absolute privilege to have you here, and once again, I hope everyone will join me in extending you a very warm welcome.
I'm really delighted to be here, and particularly delighted to be here to speak about the important work of my two friends, Lorne Sossin and Gerard Kennedy. I've known Lorne for 34 years now. I met him in the Supreme Court of Canada when he was the enormous brain helping Chief Justice Lemaire with his judicial work, and when he was a clerk of the Supreme Court of Canada. I knew him when he was Lorne. I knew him when he was Lorne Sossin Esquire, when he was a lawyer. I knew him when he was Professor Sossin. I knew him then when he was Dean Sossin, and when he was Justice Sossin, and then Justice Sossin JA, and we were colleagues together at the Court of Appeal. Regrettably, we never sat together, but I've benefited from Lorne's friendship and work for many, many years as a lawyer and as a judge, as an adversary. We sparred in court on occasion when he provided an expert opinion for the government of New Brunswick in a case in which I was representing a tobacco company trying to declare a contingency fee agreement between the government and a private law firm unconstitutional on the basis that it was dealing with the legislative appropriation of public funds without statutory authority. I lost, and Lorne's opinion carried the day. But it is an absolute privilege to be here speaking briefly about this book. I also want to say a word about my good friend Gerard Kennedy. In about 2011, I got a telephone call from Madam Justice Harbison Young at the Superior Court, as she then was, my former professor at McGill, and then Justice of the former Dean at Queen's, and then Justice of the Superior Court. And she said, there's this former law clerk of mine who you have to meet and you have to hire. He's just finished his LLM at Harvard. He was a Knox scholar at Harvard, which is one of the most prestigious scholarships and the hardest to get to study at Harvard. It's a full ride scholarship. And she said, you have to meet him. So I interviewed Gerard, and very quickly we hired him to work at the law firm where I was a partner. And I had the privilege of working with Gerard for four years before he decided to leave for greener pastures and academic work, and the rest is history. And happily we stayed in touch. When I became a judge, I'd previously been one of the editors of the Canadian Charter of Rights and Freedoms loose leaf service, which had previously been edited by David Stratus. And I decided, like Lorne, that I couldn't keep it up when I became a judge. And who did I call? Well, it was Gerard Kennedy. He was the obvious choice to take over and continue that work. So I'm really delighted to be here. I'd like to say a few words about this book. You all know it's an important book. It's the best book in the field. It happens to be the only book in the field. But that's not why it's the best book. It's the best book. It's been cited by almost every appellate court in Canada, Federal Court of Appeal, and almost 6 other appellate courts. It's been cited by the Supreme Court of Canada. It's been cited by many, many trial courts. I counted 56 citations. The most recent of which, as was mentioned, was by myself and by Justice Rowe in dissent in the recent Power decision. But I'd like to tell you how I come into a relationship with the 3rd edition honestly. In March of this year, February or March, I was struggling through my dissenting reasons in Power and trying to figure out how to describe the issue of parliamentary privilege that was before the court. The question in Power was whether or not the Crown can be sued for legislation that is later deemed to be unconstitutional. Could the Crown be sued, and is the standard based on bad faith, abuse of power, and something that is clearly wrong, which I thought were categories that were difficult to speak of when speaking of legislation duly enacted by Parliament. And I was sitting in my office struggling with this question, which was presented to the court as a question of parliamentary privilege. And my colleague, Justice Nicholas Kazira, saw the anguish that I was having trying to figure out this puzzle. And he said, you might look at Lorne Sossin's book. Maybe he's got something in there that will help you. Because all the prior case law had spoken about parliamentary privilege as being a question of curial jurisdiction. That is to say, a question of the jurisdiction of courts. but I hadn't drawn the linkage in any of the prior jurisprudence as it being a question of justiciability. The only reference that I could find that spoke about that connection was the second edition of the Law of Justiciability in Canada. So I knew I was onto something when I stumbled upon this, and lo and behold, a little time later, Gerard contacted me and said, "Would you come out to do this?" And he very generously sent me a PDF of the proofs of the third edition, and it was a bit of a race of time to get the decision released with a reference to the third edition, because I wanted to be able to cite the most recent up-to-date edition, which I did. And Gerard couriering me the text days before, literally 2 days before the decision was released by the Supreme Court of Canada. I didn't cite it as an act of friendship. I cited it because it was right on point. It helped me think through the problem, and I think it helped illuminate the law. So I wish it were not in a dissent, Gerard, even more, but it was enormously helpful to me as a judge, as I know this edition will be enormously helpful to many other judges across Canada. So congratulations, and thank you for taking the time to do this.